SJC-13131, Commonwealth versus Angel Acevedo.
Great. Attorney Alcala.
Yes, good morning. May it please the court. Ira Alcali for Angel Acevedo. It's our position that Angel Acevedo was deprived of his constitutional right to present a complete defense because the drugs and knives that were found in the vehicle at the hospital directly after the shooting were evidence that there may have been something else going on that evening.
That there was a finding that the amount of drugs was equivalent to personal use rather than distribution or dealing.
That was with regards to the marijuana, but there was also a quantity of heroin that was found in the pocket.
But I thought that was included in that finding, no?
It was packaged separately. I believe each gram was packaged separately, which would certainly show that this was not for personal use. It was for distribution. What happened here is that at the hospital, not only were the drugs found in the car at some point, but people began to gather from the south end, and some of them were known to the police, some of the people who came to the hospital right away, and some weren't. At one point, one of the witnesses, or one of the individuals rather, was Watkins, who was the driver of the car, was signaling to one of the other individuals not to answer the police's questions. So they wanted to know what happened, and the answer was, don't talk. And what happened directly after that was that there was sort of a call to retaliate right there in front of several police officers. Let's go. It was very obvious. And off they go. There's no evidence whatsoever what happened next because the police apparently did nothing, at least as far as the evidence goes. They just watched them take off in their car, off to retaliate. And the defendant, Acevedo, was actually around the city that evening for at least a few hours. He went to Shaw's to get juice with his girlfriend. He went to his girlfriend's mother's house. They were there till pretty much the middle of the night on New Year's Eve. So who did they go and retaliate against if they knew that it was Acevedo, which is supposed to be the inference? What we argue is that there was another potentially relevant inference that the jury could have plausibly found that something else was going on that evening. And they were deprived of that opportunity to do that.
Can you help bridge what might appear to be an analytical gap between the knives and the guns and a third-party culprit defense?
Yes, so if I can just go through the process of how it got there, first of all. So the Commonwealth filed 3 separate motions. One was to exclude third-party culprit evidence, one was to exclude the knives, and one was to exclude the drugs. I should add that they rightly point out in their brief that the opposition to the third-party culprit evidence does not appear to have been docketed, although it was certainly argued pre-trial. And I believe the Commonwealth concedes that it doesn't affect the standard of review, which is constitutional in any case, as we argue. But what happened is with the third-party culprit evidence, there was no opportunity to show that anything else had happened because the police did nothing. With the knives, the defense counsel argued that the knives and the drugs should come in. I'm not sure if your question is, how does this relate to third party versus?
I guess I'm asking you a very basic relevance question.
How are the knives relevant?
And the gun, and the drugs, how are they relevant to a sort of undefined third-party culprit defense or even a Bowden defense?
Because altogether, taken as one piece of evidence, if it were to be looked at that way, there was not an opportunity to develop that relevance at trial, because the police didn't do anything as far as the evidence shows. The knives didn't come in, and the drugs didn't come in, and so the jury wasn't able to hear anything that could have been developed by the defendant to flesh out what else had possibly been, evidence of an alternative theory for the defense.
But what would it have been? What's the materiality? If the trial's going on right now, and you're at the sidebar and you're seeking to offer what's found in the victim's car, what's your argument of the probativeness for it to be admitted?
The probativeness of that is that here we have a bunch of guys who are up to no good, say, that evening. It's New Year's Eve. They're found with drugs that show that some kind of drug sale was either had gone on or was going to go on. They're from one part of New Bedford. They're going to another part of New Bedford, and there were plenty of people, as was argued pre-trial by defense counsel, that were after them. Some evidence did come in.
Was that specific as to this drug dispute, that they were being hunted by somebody?
Well, there was, I believe it's Lewis Class was held for on murder charges not long after all of this, and there's.
That's the guy in the car, right?
Yes.
I'm all right. So these drug dealers that were after the people in the car, do we know who they were?
No, because we were never allowed to pursue that in any way. We don't know who they were, but at trial.
At trial,
but,
okay. So let me finish.
Sorry.
So in every case where there's personal use to a little bit more than personal use, the judge tells the defense attorney, go ahead and argue the drug dealers did it as third-party culprit.
I hear you, Your Honor, but what I think is my point
I thought there was a case that says that's not admissible.
But what's happening here, Your Honor, is not just that it is some, invisible third party. What happened here is that the entire theory of defense could have been different. There was an alternative theory that the jury could have found plausible.
Isn't it up to the defense attorney to show a nexus between a threat to a victim and a third party? And other than speculation, essentially.
Well, I'm arguing that it wouldn't have been entirely speculative, or it wouldn't have been speculative at all, because while there wasn't an obvious third party, there doesn't necessarily have to be. This isn't what we're talking about. We're talking about the entire defense, that there was something else going on that evening.
But don't you have to at least come forward with some link between this hypothetical rival drug dealer, I guess is what you're arguing, and the evidence that you're trying to bring in?
I think that the link is that there was a murder that took place not long afterwards that, in the Commonwealth's proffer anyway, was said to be probably retaliatory for the murder of Aaron Gant, which is the victim in this case, and that all three of the other individuals were indicted for, were actually serving sentences, sorry, for...
Or are you arguing that it was this teenager who Class killed who is the third party? I'm just trying to get you to articulate some sort of proffer as to the relevancy of this evidence.
I think that...
And I think that's the Commonwealth's point, is that the defendant never did.
The defendant never did...
articulate a proffer as to the relevancy of this evidence.
The proffer that was articulated was at the argument, which is in Volume 1, I think, page 86, 96, around there, that these were known to the police, and it became obvious at trial that the police did know all of these individuals, or almost all of them, that Rayshawn Lewis, who was said to be sort of at the heart of the Commonwealth's case in one way or another, although all of the testimony around him was very vague, might have been at the hospital that night. His name came up over and over and over and over throughout the trial, through Lorena Rivera's testimony in particular, and through the jailhouse phone call as well. We don't know anything else about him because that's where it stopped. That's where that whole line of defense stopped. And the defense was unable to explore that at all because none of that evidence was allowed to come in.
But isn't that your job, a trial counsel's job, to get discovery and to marshal this evidence and convince the judge? Other than with speculations? Speculative evidence? This is what he was, I would argue that this is what he was trying to do at that point. There was no other evidence forthcoming for the Commonwealth, and in particular about the fact that the police didn't pursue anybody that night at the hospital as they were loudly calling for retaliation. So we don't know. That's the Bowden issue, which is, I think,
correct,
more generous to you,
Yeah,
certainly, than the third-party
yes,
culprit evidence.
Yes. And again, but it does tie into the entire scenario that night at the hospital.
Let me ask you the question again, then, just focused on Bowden, because I'm trying to, but I'm not getting the probativeness of what's found in the victim's car to a true third-party culprit defense. I think there's a conditional relevance that it may not be missing, but I'm not hearing or getting it. Same question, though. What is the relevance that you've lost an opportunity? You keep on talking lost an opportunity to present a defense because what was found in the victim's car wasn't admitted as it relates to Bowden.
Again, because of what happened in that entire scene. So the drugs and the knives were not admitted. More so, the fact that you have a real crowd of individuals, most of them known to the police, announcing that they're about to commit a crime, that would be the inference. Let's go get them. Let's go. What are we waiting for?
Isn't that consistent with the government's theory that there's this rival gang war going on?
And yet, Mr. Acevedo is not hiding. He's around all night. And they seem to know who they're after. The defense should at least have an opportunity to see if there was anything else to that.
But wouldn't there have been a private investigator hired by the defense who could do that investigation also?
There wasn't a private investigator at that time, and that would have been helpful. But we have the facts that we have, and this is what happened.
We do, and I guess even assuming you'd gotten that evidence in, what difference would it have made in the scope of the case if we knew, or the law of homicide, if we know, okay, they're drug dealers, or there's a riot, so what?
Because in this case, every piece of circumstantial evidence had to do with anything but that. So we have these videos that purportedly show a white car driving in different parts of New Bedford. We have phone calls that happen and phone calls that don't happen. We have evidence going all the way back to high school, and the school resource officer saying that Angel Acevedo was a bad kid and caused fights at New Bedford High School, and therefore he was enemies with all of these people, and on and on and on. So the only thing that was left for the defense was to sort of go with the Commonwealth theory and try to pick it apart piece by piece when there was potentially other evidence that the jury could have considered and were not allowed to consider.
Did the jury hear about class?
Yes,
And did they hear about Watkins' arrest with the Martha's Vineyard?
yes, yes. And so they heard,
Did they hear about the other associates of the victim coming to the hospital and saying, let's go?
yes, they did.
Okay.
They did. I think that with that, again, there are two ways to look at it, and the way that I think is well, the way that we look at it is that, yes, there was evidence that these guys were, bad characters, but there was no evidence of what they were doing that night at the time of the shooting. And that would have been very helpful, especially given their call to retaliation basically minutes later, and then what didn't happen to Mr. Acevedo, who was just going around town all evening.
And you think the guns and the drugs were critical to that ability to make the argument under Bowden?
Yes, because two things, the drugs and the knives, and the fact that the police did not follow up after hearing this, this announcement of a crime about to be committed by a bunch of people that they knew were drug dealers. With that, I'll go to the second issue.
Okay.
Thank you. With the second issue, what we're discussing is Mr. Bookman, the co-defendant, had moved to Florida with his girlfriend, Alicia Ryder, about 8 months before the homicide, and they had been living there for a couple of months. She saw him lift his shirt or shirtless at a cookout very briefly, glimpsed a gun in his waistband. This gun, which he could barely describe, it was really like...
The spinny thing could be a revolver, and a revolver was used.
That's what the Commonwealth has argued. Now, she, first of all, could barely describe the spinny thing. It was really, those were the prosecutor's words.
Well, we're getting into the judge's discretion here.
Right.
So we have a spinny thing, a cowboy-looking gun, a
Right.
revolver is used. Isn't this just within the judge's discretion at this point?
Well, first of all, it was the remoteness of the time and place. So the judge has to assume that this gun has traveled 1,500 miles, one way or another, and over half a year later, this is a gun that's used, in this shooting. Now, first of all, it's not an unusual gun. Maybe if it was an unusual or rare type of weapon, there might have been some heft to that argument. But here you have actually, presumably, or arguably, from the Commonwealth's point of view, a revolver, which is extremely common, as are the projectiles that are found in various places. So to somehow connect that gun to Mr. Acevedo versus just even arguably Mr. Bookman, he's not holding the gun.
Has access to a revolver, and a revolver was used.
That's the Commonwealth's argument, and yet we have this. This gun is. There's no other evidence of the gun whatsoever, except for Alicia Ryder's momentary glance, and she says herself in the testimony, "I don't know anything about guns." The way that the prosecutor got her to describe it was, isn't it like the ones in the cowboy and Indian movies, which is, not likely that she even knew what those were, given her age and given the age of movies like that or how they're referenced.
Might be a John Wayne fan. We don't know.
It's possible.
Didn't we also have Officer Morissette showing her a photo?
Yes, he met with her and he showed her a photo. I believe the evidence was that the gun that he showed her was silver, and she said that the gun that she saw was black. Again, this is pretty vague. This isn't, this is exactly like the gun I saw in my boyfriend's waistband. That's it. It was really, again, just like the prosecutor's description of her as he was examining her at trial. Very, very vague. She said that the gun had a spinny thing. Well, again, these were the prosecutor's words, and every revolver has a spinny thing, and revolvers are quite common. So there's nothing about this particular gun that at that temporal distance in time, distance in the many, many months that had gone by, and that it was not seen with Acevedo. So in a lot of the cases where this type of evidence does come in, there seems to be some other factor for its admissibility, whether it's the defendant was the one with the gun, there was other evidence of the defendant committing the crime in some way. The Andrade case, for example, where the defendant is seen to be starting a shootout that then leads to the case that he's charged for, to that murder. Here we have none of those additional factors. There's no eyewitness. There's no testimony whatsoever about my client with a gun at any time, anywhere in his life. And there is only this testimony that is so far away and so long ago that his co-defendant had a gun. I don't think that this is enough for that to have been admissible against my client. And there were no limiting instructions, of course, which is also part of the problem.
Your request?
There was a request, and there were no. The final instructions didn't go into this either. So there was no way for the jury to.
The counsel asked, I want
Yes.
a limited instruction, and what did the judge say?
The judge declined to give limiting instructions. So if there's nothing further, could I go into the 33E issue?
Yeah, we're gonna
Okay.
rely on your brief.
Okay. Thank you.
Thank you.
Thank you.
Okay, Attorney Lee.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. This is a first-degree murder conviction based on a theory of deliberate premeditation. That was the only theory given to the jury, and the judge correctly instructed that it required a finding of an intent to kill for malice and no other regarding deliberate premeditation, which is correct. Because there's plenary review, I will try to answer questions on any topic, and otherwise I will follow the order of the briefs. I'd like to make a correction to something that was said in the previous argument regarding Lewis Class. Certainly the jury heard Lewis Class was one of the passengers in the victim's car, but the jury did not hear that he was currently incarcerated awaiting trial on a murder charge, which was subsequent to the matter in this case. That was discussed in pretrial matters. Defense counsel was aware of it, but that was not offered at trial. The jury did hear through the phone call between Mr. Acevedo and his friend Mr. Conrad. It was a jail call. The jury did hear that Aaron Watkins, who was the driver of the victim's vehicle, and Desmond Rodericks, who was in the victim's vehicle, had been convicted on a large drug bust on Martha's Vineyard, and that they had been convicted and sentenced. And during that phone call, Mr. Acevedo and Mr. Conrad were saying this was a subsequent offense, and that they were disappointed or expressed disappointment in the sentence they had gotten on the subsequent offense because there had been a prior. They were saying he got more on the prior. So the jury knew that the two of the four people in the car had been convicted on a big drug bust, and it wasn't their first conviction. Also, I want to make clear, there were no guns in the victim's car. What's in the victim's car is 2 knives in the folded position. One's in the car, one's on the ground near the car at the hospital. There's 1.02 ounce of marijuana that Lewis Class had been arrested for possession for that The jury did not hear that Lewis Class had been arrested for the possession of that, but they didn't hear that there was that amount of marijuana in the car. And then the victim's pocket is 10 grams, just over 10 grams of suspected heroin. So the jury didn't hear about the knives, the marijuana, or the heroin, but they did hear about Watkins and Roderick's having been convicted at a large drug bust on the Vineyard, and that it wasn't their first time. They also heard about a compatriot or someone in the neighborhood of the South Side, which is the victim's side. That's Rayshawn Lewis. He's the person Lorena Rivera, Mr. Acevedo's girlfriend, said was responsible for shooting Mr. Acevedo in the face and Ms. Rivera in the leg and shooting up Mr. Acevedo's car so it could no longer be used. That's the person. Rayshawn Lewis is the person she's suspected of that. And so the jury heard that Rayshawn Lewis had some convictions, and that was actually argued in Mr. Acevedo's closing argument about Rayshawn Lewis. But in the closing argument, Mr. Acevedo did not raise the convictions, the drug convictions for Mr. Watkins and Mr. Roderick's.
So your argument sort of combines the lack of relevance on Bowden, and even if it were relevant, why there wouldn't have been any prejudice. You just sort of combine those two things in your presentation. But the part about the impact of the exclusion, because there's this other evidence, actually helps the defendant's argument on relevance, because the knives and the drugs would augment everything that you say didn't cause prejudice. So with that too long prefatory comment, my question is this. Why isn't it probative, for all the reasons that you've just given, that there's knives and drugs in the car to suggest, in this atmosphere in the hospital and the nature of the entire motive of the Commonwealth, that the police should have investigated whether somebody else had a motive to commit this killing?
So the first problem for the defendant is that the third-party culprit defense was waived, and they had the evidence there that they could have readdressed. They had the convictions of Roderick's and Watkins, as well as the Rayshawn Lewis, who wasn't in the car but is part of that group. They had those materials to argue if they wanted, and if they had wanted to re-raise or reopen the issue of third-party culprit, they could have. But when asked about third-party culprit because of the Commonwealth's motion in limine, Mr. Acevedo's attorney asserted, "I don't intend on offering any third-party culprit evidence," and that's at transcript 110. Similarly, the co-defendant said, "I can't imagine," which is 110 to 111. Mr. Acevedo did argue Bowden in his closing argument. He noted that the police did all this investigation and just came up with irrelevant evidence. He noted that Rayshawn Lewis was in jail on gun charges. And that's at transcript 17, pages 7 to 8, and then 18. He could have pointed out Watkins and Roderick's and didn't do that. He could have asked the judge, "Hey, can we readdress that?"
So it's a completely fair point to address my question and say, see, look, it doesn't matter, there's no substantial likelihood. But I'm one step before, which is understanding the standard of review. Is the defendant correct that the knives and the drugs would have been probative of the Bowden defense?
And I would suggest no, because the knives haven't shown to be relevant at all. This is a car pulling up behind Watkins' car in traffic on the street where Class and Watkins lived, and firing into the back of the car, and the victim's killed instantly. There's no waving of knives. There's no drug deal. There's no evidence of anybody else even in the area. And under Commonwealth versus Andrade on third-party culprit, that doesn't help. But you can't raise a third-party culprit just saying maybe there are rival drug dealers out there. That's not sufficient. And in terms of Bowden, the police did collect all this evidence, but there's nothing to link it up to the crime. As to the knives, Mr. Acevedo's attorney was asked, what's the connection? And he said, my only argument is that if the victim's car was searched, there should be just, what was in the car when it was searched. That's at transcript 3, page 253. Co-counsel said, I don't know how it's connected. And then in terms of the drugs, the argument is, and again, somebody has a car. If they have a quantity of drugs in that car, the Commonwealth is saying that they are being killed for some neighborhood affiliation. You have a car, that car contains drugs. The victim has drugs on him. That's a matter of fact. There's no reason to keep it out. That's not any kind of, it's not a bad act, it's what they find, and that's at transcript 196. He's not linking it up. So the judge says, I'm allowing that until such time as counsel can show relation to the murder. And that's at the defendant's record appendix, page 24. That's how it comes out on the docket. This is allowing the Commonwealth's motion without prejudice. The defendant has to link it up, and that doesn't link it up. Their argument at trial is, we think you should admit it because it was there. Just being there is sufficient, according to the defendant. And that's not correct for third-party culprit under under Andrade, and that's not correct for Bowden, because what does it show? They couldn't even enunciate it in their pretrial proffer, which they're required to do. The same with the knives. And so I would suggest that the trial judge was correct in making those findings and gave counsel plenty of time to make the proffer. And there's cumulative evidence showing there are drug dealers in the car. It has made no difference whatsoever, whether you review this on that it is waived, that it's substantial likelihood, or whether you take the defendant's argument that I've just read to you as preserving this issue, and you're looking at under Wordsworth. That's not going to have any effect on the jury, because the jury heard evidence there are 2 drug dealers in the car, which is far more probative than 1.02 ounce of marijuana after the 2008 deregulation at a trial in 2018, which is after the 2016 legalization of 1 ounce. It is New Year's Eve with 4 friends in the car. The same with 10 grams of heroin in the victim's pocket. You have to show that it's like a separate trial. The defendant would have to show that gives rise to an inference of distribution when you're sitting in a car with 4 friends on New Year's Eve and 10 grams in the pocket. 10 grams is less than half an ounce. I'm sorry, this is just over 10 grams, but it's less than half an ounce. That's not trafficking weight. Trafficking weight is 18 grams. That evidence that's in the car doesn't show the people are drug dealing. You might draw an inference of that, but that's going to cause the trial within a trial. And the judge, in her discretion, doesn't have to let that happen. She gave them an opportunity to present their case on this, and their only argument at trial was because it was there. Nobody stopped them from arguing Bowden. As I said, counsel did so. And I would suggest to the court that the defendant's proffer was insufficient. This very experienced judge, I think I've already said, Judge Dupuy, carefully considered these things. She correctly stated the law on it. She knew she had discretion in some areas. And so she properly made her judgments, and those are correct judgments. I'm happy to take any more questions regarding the drugs and knives in and around the car on the victim's person. Otherwise, I'll move to Bookman's revolver. So this is a joint venture case. Mr. Acevedo had been subject of 2 serious shootings. In June of 2015, he had been shot in the leg while he was in his girlfriend's car, and he gave various stories about it, but it appears that it was a drive-by shooting. Surprise from behind, he gets shot in the leg. Meanwhile, June 2014, Bookman's girlfriend's house had been shot up while he was there. In October 2015, her house gets shot up again. That's Alicia Ryder, the girl with the revolver description. And in October 2015, Mr. Acevedo has a far more serious drive-by shooting, also from behind, also while he's in a car. This time it's his car. His car is destroyed. His girlfriend, I think a relative said he couldn't use it anymore. His girlfriend's shot in the leg. He gets shot in the face. His jaw has to be wired shut, and it's wired shut for some time. At the hospital, he says, I know who did it, but I'm not going to the police. He tells the medical personnel that. which is consistent with this senseless neighborhood war in New Bedford, which is testimony is a very small area, but it has 3 distinct neighborhoods, 2 of which have had long-going disputes since the 1990s, which nobody can really point to how it began. It just is. And Mr. Acevedo and Mr. Bookman live on the west side, and now Mr. Bookman also was experiencing being tracked or stared down. He was in a restaurant, and the victim himself came into the restaurant and stared them down. He's like, don't pay any attention. He's with his girlfriend. And then their car's driving by the house, the girlfriend's house, which has been shot up twice. And the car is driving near where she works. And when they're walking down the street, the car slows down next to him, and sometimes it's the victim's driving. And so that's what's going on with Bookman. Mr. Bookman, I'm sorry. Mr. Acevedo has the first shooting in June. October 2015, the more serious shooting. He feels very badly. He thinks he's the target, and that his girlfriend got hurt because of him, because of the position he put her in. She's the one who says it was Rayshawn Lewis, but when she's testifying, she said that she couldn't remember or didn't think she'd ever told Mr. Acevedo that it was Rayshawn Lewis. Rayshawn Lewis, like the victim, like Aaron Watkins, like the group that was staring down Mr. Bookman, are all from the south side. And Mr. Acevedo and Mr. Bookman are from the west side. In addition to that, Mr. Acevedo has a long-standing dispute with Aaron Watkins. Aaron Watkins is the driver of the maroon Mercedes SUV that the victim is sitting in when he gets shot to death. So that's the background of it. And what we have here is this joint venture where Mr. Acevedo goes and rents a car from his sister's boyfriend in Maine, and it's the white Ford Fusion. It's distinctive for its sunroof and its aftermarket black rims on the wheels, which is unfortunate for him because it makes it far easier to track it on security video throughout the city after the murder. So he gets that car on Christmas Eve, and a week later, this incident happens. And what we have for the evidence is that he's with his girlfriend's family, celebrating New Year's Eve, and he says he has to get a haircut. And right after the haircut, he calls Bookman, 521, 526. By 6:55, they're together. Bookman's in the passenger seat, Acevedo's in the driver's seat. From the ballistics evidence, it looks like the passenger's the shooter. That's what the Commonwealth argued in its closing, because there's gunshot residue on the A-pillar passenger side near the mirror, which is in reach of the passenger. And then they drive south. They both have parties to be at. They're supposed to both be in the West End at the parties, but they stop at Silva's, which is in the West End, and then the security video maps out their chart as they go straight down into the city. A police officer drove that route from 702 to 718, Silva's, the suspected route, to the area where the shooting is, and it's about 40 miles an hour, not leaving a lot of room for stops. Nor do we see the car stop anywhere on the security video we have. So what we have is Acevedo has the car, makes the call, he's together with Bookman. Bookman's got a gun. They drive straight into, for lack of a better word, enemy territory.
Well, I guess,
So he picked up the gunman, is why it's relevant against him.
I understand, and your very careful description of the evidence of joint venture probably makes my question easy enough to recognize why it probably wouldn't have made a difference. And of course, nothing's easier than quarterbacking on Monday morning, but wouldn't it have been better for the judge to have given a instruction that if you find, because the jury does have to independently find joint venture in certain circumstances, if you find there's a joint venture, you can consider the gun against this defendant. In a perfect world, that would have been the instruction, right?
Sure. So, yeah, I agree. We can look back and say, oh, hey, here's a better instruction that could have been done, but that's...
There wasn't. No, I mean, it's not that that one's better. It's just that the gun came in against the defendant without a limiting instruction.
So this is true. I would state this. The defendant is correct that the issue is preserved on the request for an instruction that it not be used at all against Mr. Acevedo. And that would have been incorrect to give the instruction for it to be used against Acevedo because it's a joint venture. The evidence shows Acevedo planned this out. he went and got the car, then he goes and picks up the gunman, and the gunman fires. So it can be used against him. And yes, she did give a joint venture instruction, and yes, that would have been helpful to have that instruction. However, the issue is not preserved on propensity. This judge gave many instructions on propensity so that Acevedo's history could not be used against him. And she gave many instructions for Mr. Bookman that Acevedo's statements could not be used against Mr. Bookman. She was very open to giving those instructions. And when this came up, she specifically asked, you know, do you want an instruction? And the defendant said, no. I said, I want an instruction on that this can't be used against Acevedo. And she says, it's a joint venture, I'm not going to do that. I'll entertain any other instructions. And he did not make a request for that instruction at that time. That's transcript 12, pages 142 to 144. And then after the judge's instructions, there's no objection of any kind for the instruction you're suggesting or the instruction on propensity.
And this isn't the type of case where knowledge of a firearm has to be separately instructed as well, correct?
No, because it's murder. The judge did give that instruction because it's unlawful possession of a firearm charge. So she gave that. She said, when you have to prove that the person knows about the firearm, then you have to have that. And that
As to Acevedo,
it was for both of them. They both had unlawful possession of firearm. And the jury could not have convicted them for unlawful possession of a firearm based on the Florida incident because her instruction on that ground required them to make a finding that the possession was in a car. It's in a vehicle throughout. The Florida incident was at a cookout and in a home and not in a car at all. So they couldn't have used...
You'll excuse this fastball down the middle, but you can see it's not manifestly unreasonable at that point if the gun's coming in to not request instruction. Well, before you consider this gun, think about whether or not there's a joint venture and really sort of tying in tightly its relevance to the theory. I mean, that could be a reasonable defense not to request it in that context.
It could be, but we don't have any post-conviction motions talking about what the strategy was on this. I would note, under Commonwealth versus McGee, when the gun is a means to commit the crime, the propensity instruction for firearm isn't required. And in this case, Alicia Reiser's testimony makes it look like it's a revolver. She's not a gun expert by any sense, but she testified in a manner that's consistent with that. And the evidence, the ballistics evidence, suggested very strongly that a revolver was used in this case. And so this could be the means to commit the crime. And so we do see evidence of deliberate premeditation, that Mr. Acevedo went and got the car, went and got the gunman, drove down the road right into enemy territory, and fired from behind in the same manner that he had been fired on from behind on 2 different occasions. If there are no further questions, I would ask this court to affirm the convictions in this case. Thank you.